Good afternoon, everyone.
Good afternoon.
All right.
I apologize.
We're so grateful here to be here. Thank you all for being here today as we begin our work meeting with the Planning Commission here in the city of Portsmouth. We'll turn everything over to Dr. Russell, and she will lead us as we prepare for our work session.
Good afternoon, everybody. Thank you again for being here. We have three of our commissioners. We have a light agenda. Typically that means it ends up being a long meeting. We're going to go over our 3 agenda items, and then we're going to just guide you through a facilitated exercise about training and what opportunities you would like to explore next. Our first agenda item is use permit number 2510, an application by G. Palmer to operate a drug and alcohol treatment facility at 901 Enterprise Way in the general mixed-use GMU zoning district. The property is owned by Mayflower Alps LLC and is further identified as tax map number 24, parcel 164. The future land use map of the Build One Portsmouth Comprehensive Plan designates this property for commercial uses, and Principal Planner Mrs. Valerie Malzone will make the presentation.
Good afternoon, everyone.
Good afternoon.
My name is Valerie Malzone. I'm a principal planner with the City of Portsmouth. The first application before you is a request for a use permit to operate a drug and alcohol treatment facility at 901 Enterprise Way. The property is approximately 1.3 acres in size and is zoned general mixed use, or GMU. It is located in the northeastern portion of the Link District. The property currently contains a 27,300 square foot building that was constructed in 1987 with a parking lot containing 20 off-street vehicle parking spaces. The building was previously utilized as an assisted living facility that housed 55 residents. The surrounding area consists largely of public and institutional and residential uses. Public and institutional uses zoned general mixed use, or GMU, surround the property to the south, east, and west. These uses include religious institutions, an assisted living facility, and a cemetery. Single-family residential uses zoned urban residential, or UR, are located to the north. The applicant proposes to convert the existing structure into a drug and alcohol treatment facility with minimal interior improvements and no exterior improvements. The proposed facility would operate as a clinically managed, high-intensity residential care program regulated by the Virginia Department of Behavioral Health and Developmental Services. The facility would accommodate up to 85 residents undergoing treatment for drug and alcohol addiction who would reside at the facility for a period of 30 days. In the submitted application, the applicant provides details of security measures that will be in place during the facility's operation. These include key fob restricted entries, installation of security cameras in common areas and the exterior of the building, and staff-conducted check-ins for each patient every 30 minutes. The facility will be staffed 24 hours a day, 7 days a week. In June 2025, the Board of Zoning Appeals granted a special exception authorizing reduction in the number of required off-street vehicle parking spaces for the proposed use from 55 spaces to 20 spaces. The existing parking lot provides these 20 spaces. Staff is recommending approval of the applicant's request with the recommended conditions. Staff finds that the proposed use is appropriate at this location and is consistent with the recommendations of the city's Build One Portsmouth Comprehensive Plan and Innovation District Plan. Although the future land use map designates this property for commercial uses, the subject parcel is located within a transitional area between commercial and residential development and is immediately surrounded by other like public institutional uses. The proposed facility would maintain the property's existing use as a healthcare facility, which conforms to the surrounding area without adversely impacting the commercial activity areas located further south. To date, the Planning Department has not received any public comments regarding this application, and I will now stand by for any questions.
What is the name of the company who's looking to put this together?
That was not provided in the application, but the applicant would be able to answer that question. There's an agent representing them.
So there's an agent representative.
correct.
This has nothing to do with behavioral health here in the city of Portsmouth, correct?
That's correct. And the applicant is 901 Enterprise Drive, LLC.
So this is a private sector, correct? Am I right?
Correct, yeah.
They're based out of Virginia Beach.
And so as a substance abuse, this is going to become more of a, not like a methadone clinic, or more of like partial hospitalization or intensive outpatient, or
I will defer to the zoning administrator because our uses do depend on what treatments are being provided there. A drug and alcohol treatment facility and a medical, outpatient medical facility are defined differently by the zoning ordinance.
right? Because we have one up the street on High Street. So with behavioral health, so I'm trying to figure out.
Correct. There are also multiple uses that could fall into.
Okay, so Mr. Tyler Rose, who's representing the applicant and is present, who, you know, at the our public hearing or at this time could likely definitively answer those questions. But what is proposed is an 85-bed alcohol and substance abuse treatment facility. So that's an inpatient where the services.
Alcohol and what?
Substance abuse, drug and alcohol. 85-bed treatment facility where the services for treatment as well as room and board are provided on site in a secured facility.
Okay. So a lot of questions I need to be asking them. Tons of them.
We'll try to answer what we can now, but yes.
So this where they'll be living? This will be a headquarters for them to live,
For
correct?
a period of 30 days, they will reside completely on the property, yes.
The 30 program, do you know if it's Medicaid funded or private?
I am not aware of that.
And I know they're trying to get a permit to use this, but who would they been licensed through to provide this? Are they going through DMAS? Are they going through the Department of Health Behavioral Services?
In the application, it says Virginia Department of Behavioral Health Services.
So I can go in the database and look there. What I got in there? Any other commissioners have any comments concerning? Yes, sir.
Yes, good afternoon. Can you tell me what happened to the living assistance facility? Did it go out of business, or is G. Palmer or the Enterprise Associate, are they trying to transition it over to a drug and alcohol facility?
That information was not provided to us in the application. We were not let in on that information, so I'm not sure. So you'd have to ask the applicant.
But the facility wasn't vacant.
Correct.
Okay, so it was already established. Okay, good. And then for security plans, do we, I don't know the process specifically, but do we receive also contingency plans as well? I read through the packet, it said that within the 24-hour period, there will always be 10 to 14 people, and that they will have the procedures in place if there was emergencies. But what if, for example, something crazy goes on and is less than 10 people, then what are the emergency plans then to ensure that, you know, everyone's safe and the building's secure? So I don't know if we accept contingency plans or just whatever they give us.
Whatever they give us. With that
Yeah.
standpoint, yeah.
And the zoning administrator could include as part of the security plan that it has to be minimally staffed with X number of staff members for these shifts. that can be part of it.
And tangent on the program, when it comes with DMAS or the behavior, they have to follow those guidelines of the structure of any program, substance abuse. I'm a certified substance abuse counselor, so this is what I've been doing for 21 years. So I know the ins and the outs of the staffing and the requirements that it does require. That's why I have a lot of questions. But they have to follow those DMAS requirements, especially when it comes to anything of Medicaid building, because I'm sure that's exactly who's going to be getting billed for this. But they have to follow the changing guidelines. They have inspections that will come in over and over again, pop-ups that will come in. They have a licensed person that is assigned to ensure that they are following those guidelines. So they have to follow guidelines in order to stay in business and keep that license.
Okay, so in your experience, you have never seen a situation to where they're operating under, not intentionally, but unintentionally because, life happens to people and something happens and then now they're short-staffed.
I work in mental health. We're always understaffed. That's just a part of the thing. You just have to learn how to keep hiring. And, it's just, the mental health we're all understaffed.
And you have a list of contracted employees.
Yeah, so.
Correct. So
Contractors you can.
that brings to my point, there should probably be a contingency plan noted within the packet of if something like that was to happen, if they were understaffed, what would they do? So that's all.
Is there any other commissioners have any comments, questions, concern? Anyone?
So our next agenda item, Ms. Malzone will also present, and it is a proposed ordinance amendment. The City of Portsmouth proposes to amend City Code Chapter 9.1, Chesapeake Bay Preservation Area Overlay District ordinance to include provisions to assess the impact of climate change and sea level rise on proposed land development in the resource protection area during the project review process, as required by recent amendments to the Code of Virginia.
Okay, good afternoon again. So this is the proposed code amendment to Chapter 9.1, which is Chesapeake Bay Preservation Area Overlay District Ordinance. So a little different from what was in your packet. We are now recommending deferral, so it will be a different staff recommendation that was in your packet. Local program compliance with the Chesapeake Bay Preservation Act is overseen by the Virginia Department of Environmental Quality, or DEQ. DEQ has requested that the city provide a copy of the proposed ordinance amendments for review prior to adoption. Planning Department staff is recommending deferral of this case to the October Planning Commission public hearing in order to provide additional time for DEQ to review and then for staff to incorporate those comments into the ordinance once received. The proposed amendments were submitted to DEQ on August 20th, and the deadline for ordinance adoption is October 31st, 2025. I will now stand by for any questions.
Yes, Commissioner.
Good afternoon. First question, why the shift?
So the shift came, DEQ informed me that the shift came that they have been getting other localities adopted ordinances, and they were finding that they did not properly meet the state mandated requirements. So now they're requesting that localities submit it to them before adoption, so they're not having to make amendments and re-adopt it.
Okay, thank you. And then how will the city make sure that resiliency assessments are consistent across projects? Have you all created already like templates or whatnot?
No, so we have not created the templates yet. So upon adoption of the ordinance, the effective date is proposed to be July 1st, 2026. So in that in-between period is when staff will be preparing documents. The resiliency assessment form would be the same for all applicants and reviewed by the same Chesapeake Bay Preservation Area Committee. So those materials will be made by staff, reviewed by staff, and then potentially reviewed also by DEQ.
Okay, and then, okay, thank you. And then my next question is, in the definition part on page 2, it says adoption measure means a project, practice, or approach to mitigate or address the impact of climate change. Are there any clear examples of or criteria that distinguish the types of adaptation measures, since the definition includes these three types?
Yeah, probably the most common adaptation measure that we're going to see around here is a living shoreline. So that's a shoreline stabilization structure constructed of natural materials.
Okay, and then how will we go about knowing if the proposed mitigation works, or if it does not? Do you already have a system in place, or is that all for us to figure out?
That is yet to be determined. It would be determined in conjunction, on a case-by-case basis, in conjunction with our engineering department. So it would be a joint effort, not done, reviewed specifically by planning.
Okay, I'm just pointing out just in case we haven't hit it. And then I have two more questions. With this new policy, how will we assess its impact on existing vegetation and land or water movement, if that makes sense?
I think I understand what you're saying. So you're saying what, existing development and existing vegetation? So
Correct.
these amendments would only apply to new development and new projects. So unless they wanted to redevelop a parcel of land, these amendments would not impact existing vegetation or existing development.
Do we think by us not looking at the already existing, that there's some risk to that? Or will be okay? I'm just saying, if no one's looking at the existing, how do we know that we're on?
Right. They are looking at the existing in the way where there's the preservation of mature existing trees within there, but for existing development, unless they are choosing to, redevelop it, there's no way to go through and, review and hold people accountable for new standards for old development.
Okay, just want to make sure that if for some reason that the new development changes the already existing one, that we're aware of what the impacts are. And then, last question, are the developers expected to address the full 30-year impact upfront, or can it be phased adaptation?
The 30-year lifespan impact would have to be evaluated at the time of the application. So if they wanted to phase the project, it would be reviewed in phases.
Correct. And
Okay, sorry, I might not have understood your question.
You're on the right point.
yeah.
My question is, are we, as the city, allowing phased?
So that's a determination of the engineering department. Unless they determine that land disturbance may be phased, we don't encourage it because typically they want to evaluate the land disturbance as a whole. So they typically don't allow phased projects for the sake of, getting around state codes and
Okay.
requirements.
I only ask that because at least in my opinion, I think phase helps the city because now you're looking at data in real time instead of just projecting out to 30 years and possibly wasting resources. Because in 15 years, everything will look different. But if you phase the plan accordingly during that time frame, only problem is that it's going to have to evolve a good monitoring system, right? Or it then impacts us. But yep, I would just make sure that if we're not going to do phase, that engineering includes that in this policy or whatnot.
I
So
see.
that it's understand from the
Yeah.
developer side that, hey,
Yeah, that's
30.
a case-by-case determination, unfortunately, so it's hard to give a definitive answer, but yeah.
okay, that's all I have. Thank you. Thank you for your time.
Any other commissioners? Any comments, questions, concerns? All right.
Okay, our next agenda item will be presented by Ms. Patrice Branch, a planner in our office, and it is a second code amendment. The City of Portsmouth proposes to amend Chapter 33.1 of the City Code, and that is the subdivision ordinance, to update specific provisions to ensure consistency and compliance with recent amendments to the Virginia Code.
Good afternoon, Planning Commissioners. My name is Patrice Branch, and and I'm a planner with the City of Portsmouth. So last month during the work session, staff provided you all an overview of the recent legislative changes that were enacted during the 2025 Virginia General Assembly sessions. These changes essentially impacted the local land development processes, and as a result, requires updates to our local subdivision ordinance to ensure compliance with state code. So following that work session, the Commission adopted a resolution during the public hearing initiating staff to prepare amendments to the city subdivision ordinance for your consideration with the intention of having further adoption by City Council. So today I'm just going to present the proposed amendments to the subdivision ordinance. So to begin, listed here is a brief summary of the key 2025 Virginia Code amendments that affect the local land development processes. So Senate Bill 974 removed the approval authority from the Planning Commission and the governing body and assigns the authority to the designated agent. House Bill 2660 shortens the review time frames for approvals. And then in addition to aligning with these legislative updates, we are also proposing amendments to include routine adjustments that will improve the clarity, consistency, and usability of the ordinance. So the proposed changes fall into three major categories. So first, staff is proposing amendments to the authority, administrative enforcement, subdivision exception, and major subdivision procedure chapters of the ordinance. These sections are being revised to reflect the changes that came about as a result of the Senate Bill 974, which shifts the approval authority from the Planning Commission / governing body to the designated agent. Second, staff is proposing amendments to the procedures for preliminary plans for both the minor and major subdivisions. These changes are required to comply with House Bill 2660, which shortens the review timeframes as well as outlines new procedure for plan resubmittals. And then lastly, the following sections that are listed here are the routine adjustments that staff are proposing amendments to. These include removing outdated references to Virginia State Code sections, adding submittal requirements to reflect current administrative review practices, addressing other areas of the ordinance that are in non-compliance with the Code of Virginia. So overall, staff is recommending approval of the proposed amendments to the updated to update specific provisions of the subdivision ordinance. These updates will improve clarity and consistency in the administrative review process, as well as ensure compliance with the Code of Virginia. This concludes my presentation, and I'll stand by for any questions.
All right, can we go back, thank you so much for your presentation. Can we go back to section 33(1) through 4, about authority? Can you give me a little bit more when they're stating that the planning director and the city engineer shall have the powers and duties necessary to carry out functions assigned to them under the chapter and the Code of Virginia?
So, let me see. Are you looking at the actual statute or the actual section in the ordinance?
Section, yeah.
So, let's see, 33.
Page 2. Page 2 of the draft.
Page 2. Page 2. So essentially what we did was originally the authority was assigned to the Planning Commission, which was given under City Code Chapter 2, and then the Planning Director under the zoning ordinance, which is Chapter 40.2. We just updated it to show the Planning Director and the City Engineer as our review authority powers, or powers who are given to them as reviewers. We didn't change anything else from the section.
May I speak? The subdivision, in every locality that I've worked in, the subdivision review process has always been questioned because it is a by right use. And so if a property is zoned to permit, say, a 10,000 square foot lot, and that is what the plat shows, then it goes to Planning Commission for an administrative. This is acceptable. Typically, the Planning Commission will review for infrastructure like roads. Your road network can accommodate that use. And so the parties that sign off on a plat before it goes to record are the city engineer and the director of planning, as well as the property owner. and it is removing the Planning Commission review of the process, which should expedite the time to construction and help with what I call the debt service costs of carrying a property from the beginning to when they're able to sell lots. So it's a positive thing for the development community.
Can you tell me a little bit more about your experience, Dr. Russell? Like what was wrong with the process in the past, and what was the final trigger that made the assembly vote on this?
So I don't know the answer to that question, but I do in terms of what made well, it's probably like it usually is.
Was it lobbying? Was it the city?
It could have
Was
been
it the city?
lobbying.
Was it developers? Was it a mix?
I don't know, but let me answer the first part of your question. What were the concerns that were raised by the development community? And it was the delay in the timing for when their project when they could sell lots. And so the site plans, development plan review process is lengthy and expensive. And that process can't really get underway until you get a commitment for how the lots are laid out and the road network is laid out from the Planning Commission. And so you take an administrative process and assume it's deferred for a month. That's 30 more days of interest payments and debt service that they're carrying until they can make a dime on a project.
And how many applications like this has the city of Portsmouth received?
So the city of Portsmouth has very few large lots remaining where you could do what we call a major subdivision. My tenure, just about 18 months, 2.
Two. Okay. So it's not common here.
Well, only because we're an urban core community and essentially built out with less than 10 large tracts left, where you could get upwards of a 100 lot subdivision.
Okay.
Okay.
I have more questions, but I'll pass it to the other commissioners so they can ask any questions.
Anyone else have any questions? So this was basically tied down from the whole back and forth, cut down on costs, and ensure that kind of minimizing the process of getting things through.
Well, it's an administrative process, so
Yes,
just like
right.
a building permit, it's, you meet all the requirements, you get your
Right.
permit. The subdivision is the same way,
Yes, ma'am.
but it up until now, it's had to go through this body for an approval.
It's tedious and it's kind of difficult, especially somebody who's never been in that position and put that money up.
And
It's very tedious
yes,
and costly.
hundreds of thousands of
Yeah,
dollars.
costly. Okay.
And this doesn't conflict with any other local ordinance that we have? Okay, and then does designating an agent, I'm guessing that's just someone on the planning staff, the agent?
The city manager designates an agent.
Okay. Does that introduce any new legal liability? Is it going to be up to that agent instead of a body, 2 bodies actually? Does that introduce any legal risk for us?
Yeah, no, it doesn't, and in fact, it's sort of how it works in almost all cases at this point. The agent is technically the director of planning now under the ordinance, and this just simply expands the staff control to what used to be controlled by the Planning Commission.
Okay,
Says no more or less liable for anything. basically.
okay, but the planning director gets to delegate to staff in order to carry out that process, right? So then how do we ensure that interpretation is consistent across each application when it does come up, if it's just one person? Or would you have a small body committee that says, okay, yep, we'll concur with that? Is it only up to the
I have a
8?
group of professional planners that I have on staff that do professional work, so they're gonna make sure that they do professional work each time.
Okay. And then I saw the executive summary that there's a removal of requirements to notify adjacent property owners
Correct,
of public hearing.
correct, because there's no longer a public hearing.
So how do we still continue to notify those members that there is a possible change that's going to happen?
So since it's an administrative process, the only reason we were notifying them because it was going to planning commission, it was being advertised. It's no longer being advertised. So we're not required to notify them.
So we don't believe that they should be involved in this process even though it's not in a hearing? Like they shouldn't be able to come to planning staff and say, hey,
So again, it's an administrative process. So if they had input, when you review subdivisions, you kind of review that it complies with the ordinance. So if it doesn't comply, then we give them the corrections needed. If there's really no public feedback needed, that would kind of affect the ordinance in that per se, because it's like, it's kind of a black and white thing. If it's there, it's there. If it's not, it's not.
okay. So the only way we will see this application if there's a rezone request.
Correct, or yeah.
Subdivision.
Yeah.
Understood.
Minimizing micromanaging.
Yep. A decentralized process, yeah. That's all I have, thank you.
Any other commissioner? Other comment, questions? Thank you so much for your presentation.
All right, thank you.
Dr. Russell.
Chairman Curry, at this point, we'd like to go over the Board of Zoning Appeal agenda items for the September 24th meeting, and we have quite a few of them.
Good afternoon, Commissioners. I'm Trevon Boone, Zoning Administrator for the City of Portsmouth, and pursuant to Section 15.2-2310 of the Virginia State Code, the Zoning Administrator shall notify the local Planning Commission of applications received for special exceptions and variances. The Planning Commission may send a recommendation to the Board or appear as a party at the hearing. We have 10 items that are scheduled for a public hearing before the Board of Zoning Appeals on September the 24th, 2025. 7 of these items request a special exception per the zoning ordinance section 40.2-3535 subsection B subsection 13 to authorize reducing the minimum required interior side yard setbacks from 7 feet to 3 feet to construct detached single-family dwellings on non-conforming lots approximately 25 feet in width and 100 feet in depth. Those addresses are 2328 Elm Avenue, which was deferred from our August meeting onto our September meeting. They are requesting a variance as well to reduce the corner yard setback from 10 feet to 3 feet. The next one we have is 1905 Columbus Street. The next one that we have is going to be is for a variance for 3329 Carney Farm Lane, which is to authorize respectfully a principal structure with an entrance facing away from the street from which it derives its street address for an accessory structure for the front facade of the building. The next one we have is 2004 Peach Street, which is to authorize a reduction of the minimum required yard setbacks from 7 feet to 5 feet and the front yard setback from 25 feet to 7 feet. The next item we have is 1604 Richmond Avenue, which is for a variance as well, which is to authorize a reduction of the minimum required rear yard setback from 25 feet to 14.6 feet to accommodate an addition on the rear of a detached single family on a lot that's 50 feet in width. The next we have is 610 Phillips Avenue, which is for a special exception. 1213 Center Avenue, which is for a special exception. 612 Phillips Avenue for a special exception as well. And 3707 King Street, which is for a special exception as well. These are all the cases that we have for the Board of Zoning Appeals. I'll stand by for any questions, comments that you may have at this time.
I have a question.
Let's take it.
In terms of King Street is already a very narrow street. So what would be the justification for what they are proposing to take it even more strict, more smaller, more narrower? Because it's already a very narrow street, so I was just curious about that after seeing this map.
Yeah, it's pretty much for the lot, so they can build on the particular lot, not for the street, but for the build on a narrow lot.
Right, but it's gonna narrow the street, isn't it, or is it not?
It's not going to impact the street at all.
It won't impact on the
No,
street
no,
at all.
no.
The street will still stay narrow like it is.
Yes, ma'am.
Right.
Okay.
From the days of the horse and buggy, I think. All right, thank you.
You're welcome.
Commissioners? Thank you, Dr.
All right, planning commissioners, we have so far completed 2 commissioner training events with you. One, the Chesapeake Bay Preservation District ordinance, and after that one, we asked commissioners what their interest was, and the feedback we received is you wanted to know what happens after you've considered a case. So we went through the permitting process with you. That's all the feedback we've gotten to date, and so rather than assume we know what you want, we're asking for your feedback on additional training opportunities that we should prepare for the commission. Do you have any ideas?
Anyone have any ideas, suggestions? Not at all?
I'd just like to hear the other departments or authorities to update us on what's going on throughout their business. So, for example, like the development department head or whomever come up here and to speak to us of what's going on throughout the city and where we can be most useful if needed. I guess industrial, just come up here and speak to us so that we are better aware of what's going on.
Maybe like one department at a time where we have a lull. We advise you all about the Government 101 sessions, right? That's coming back up this fall. It is by application or request only, so that's where you'll get a lot of what's happening and body of work done by other departments. But that's a suggestion that we'll bounce off on, particularly the departments that we work with closely. Okay, that's a good idea. Anybody else?
I have when you were referencing about the amount of acreage still available in this city, I do know of a very large tract still available in this city. Don't beat me up. Sportsplex, all that acreage over there, right off of Portsmouth Boulevard, intersection right into Roanoke Avenue where I happen to reside. And the point is this: we have a number of schools that have the availability to accommodate the various sports activities for our children. So I just don't understand the reason for the sportsplex acreage being used for recreational agendas for our children when we do have other alternatives. That's just my feedback on that for thoughts, City Manager.
You may want to talk to your council.
I'll go through you.
I don't carry other people's order for them.
And you know, I have no problem with that. I just had a word with them about this collective bargaining, so
Yes.
I can do that.
Absolutely.
I can do that.
That's the spot that you.
I'll take it right to them. Thank you.
My pleasure.
But just to let people know, we do have some large parcels out here.
What do you think about, we'll make that the next opportunity, the large vacant parcels that are privately owned that are undeveloped? And what looks
This
like
one is
Well, I think
publicly
she's
owned.
talking about redeveloped, not just undeveloped. Yeah.
Yeah, I'm talking about undeveloped. I'm talking about undeveloped pieces. Okay, so let's do that, and then we'll add to
I would
that
love
what the
that.
zoning and what we believe the highest and best uses are, right? That'll be interesting. We can do that.
I'm gonna need some place for the
hear the
police
mighty-
department to go, right, at some point? Into the police department gonna have to come off of the waterfront and go someplace else, or?
We already
I'm assuming that
have
may
a
be the
location established behind Maryview Hospital where.
Is that
definite?
definite?
Where there used to be a theater there.
Willett Hall.
Willett Hall, yes.
Yeah, that's definite.
Nothing's definite until we start breaking the ground.
Okay.
Okay. But that's the planned location at this moment.
Might want to consider sportsplex, but I'm just saying.
All staff has Commissioner Curry.
All right.
Needed.
So that's all here for this private meeting. We will adjourn this meeting until our public hearing at 1:30. All right. Thank you so much. Good afternoon, ladies and gentlemen. I would like to welcome you all to this very important meeting today, Tuesday, September the 2nd, 2025, in the City of Portsmouth City Council chambers. Madam Secretary.
Thank you, Mr. Chairman. Commissioners, we will now have roll call. Please indicate your presence electronically. Six members of the Planning Commission are present.
Commissioners, before you are the minutes of August the 5th, 2025, public hearing. If there aren't any changes, we are in need of a motion. Today, we need a motion.
Commissioner. Is someone
I
else?
so
Commissioner-
move that we approve the minutes.
Thank you, Commissioner Jiggers. Will there be a second?
Second.
Thank you, Commissioner Glover.
Thank you, Mr. Chairman. We have a motion and a second to approve the minutes from the August the 5th public hearing, and you will be voting electronically. The minutes are approved by a vote of 6-0. Items reviewed today will be presented to City Council for action at their October 28, 2025 public hearing or as otherwise noted. Announcements of future meetings and conferences. Our next scheduled work session is Tuesday, October the 7th, 2025 at 12:30 p.m. City Council Conference Room, followed by public hearing at 1:30 p.m. City Council Chamber. Planning Commission's rules limit a speaker to 5 minutes to speak. We also ask that everyone please silence your cell phones at this time if you have not already done so. Our first item is UP-25-10 Link District. G. Palmer requests a use permit to operate a drug and alcohol treatment facility at 901 Enterprise Way in the General Mixed Use GMU zoning district. The property is owned by Mayfair Alps LLC and is further identified as tax map 24, parcel 164. The future land use map of the Build One Portsmouth comprehensive plan designates this property for commercial uses. Our staff coordinator is Valerie Malzone. Will the applicant or the representative for this application please come forward and present your application at this time?
Good afternoon. My name is Tyler Rose. I'm an attorney with the law firm Williams Mullen. My business address is 222 Central Park Avenue, Suite 1700, Virginia Beach, Virginia. Here today on behalf of the applicant. I'd like to thank Ms. Malzone and Dr. Russell and the rest of the staff for the hard work on the application and for the recommendation of approval in the staff report. The applicant is seeking a use permit for a residential drug and alcohol treatment facility at 901 Enterprise Way. The proposed facility will host a maximum of 85 residents who are undergoing treatment for drug and alcohol addiction. The residents would reside at the facility for a period of up to 30 days. The facility will be professionally staffed 24/7. There will be 10 to 12 staff members who will work a shift, and there will be 3 shifts with lower number of staff members during the overnight hours. This will be an adaptive reuse of a existing nursing home operating under Mayfair House. There'll be no exterior improvements, and there'll be minimal interior improvements. The existing parking lot will be 20 parking spaces. As mentioned during the work session, there was a special exception permit received to reduce the parking. So there will be sufficient parking for the operations. There will be no patients driving to the facilities. There'll be no patient visitors, and all the parking will be only for staff. So there will be sufficient parking for the operations on site. The property will have various security measures to ensure the safety of the residents, staff, and the surrounding community. It will be staffed 24/7 by all team members trained in de-escalation techniques and emergency response protocols. The access will be controlled by key fob entry. There'll be security cameras in the common areas and around the perimeter of the building. Staff will conduct physical check-ins on patients every 30 minutes to ensure that they are well and present. And all activities will be conducted indoor, and the residents will not leave the building or gather in front of the property. They will have an ability to be outside within a gated area within the perimeter of the building. There's 2 fresh air outdoor gated facilities internal to the building as well. So the property will be operated as a clinically managed high-intensity residential care program regulated by the Virginia Department of Behavioral Health and Developmental Services. It's commonly referred to as an ASAM 3.5 facility, for those of you familiar with the designation and the requirements there. It'll be a multidisciplinary facility treating the physical condition. Yes,
Can
sir.
you repeat that? You said the ASAM 3.5?
3.5, yes, sir. Yes, sir. So it's a multidisciplinary facility treating the physical conditions and also the underlying mental health associated with the addiction disorders. In order to qualify, the facility must provide and maintain certain level of care in accordance with state regulations. According to the registration from the Virginia Department of Behavioral Health and Developmental Services, there's only one other facility in the city of Portsmouth that is registered according to that website. So this would be the second facility of that nature, and obviously filling a great need in the city. So I do have Michael Rothstein here with Genuine Care Consulting to speak more about the regulatory components of the ASAM 3.5 facility and how this facility will operate. He's a specialist in this type of area, so I'll yield my time and bring him up if that pleases the commission here.
You want to ask Stephen Mann?
Good afternoon. My name is Michael Rothstein, Rothstein. I am the owner and founder of Genuine Care Consulting. We are a consulting group that handles specifically substance use disorder facilities, multiple states, including Virginia. We have a couple properties we've already worked on. So I'm here today to talk about this specific location, which is a 3.5 residential level of care. The process is as follows. We first would need to obtain a national accreditation. So we typically use CARF as our national accreditation body. CARF reviews all the policies and procedures, our staffing plans, emergency evacuation plans, things like that, to deem us a nationally accredited facility. We would then apply to DBHDS for our 3.5 license. That's once we have our use certificate, fire inspections, any building inspections required. They review all of our policies and procedures. They come out to do a site visit to ensure everything's in order. This specific facility will also be taking Virginia Medicaid. So we'll have a DMAS number, and this DMAS, it's for,
DMAS.
Yes, correct. Sorry, a lot of acronyms, so I
Yes.
apologize.
A lot.
So yes, we will have a Virginia Medicaid number and the subsequent MCOs so that we can treat all populations, whether they have commercial insurance, Medicaid, or unfunded.
Good.
Let me talk a little bit about what the program looks like. So when we have a potential client coming in, the facility will do a pre-screen. It's a list of about 14 to 16 questions to make sure they fit our level of care. This facility, dealing in substance use disorder, we do see a lot of co-occurring mental health, but there are screening questions on there to make sure that if they have a mental health diagnosis that is too high for our level of care to assist, we would refer them out. And we work with local partners first to find stabilization. If they're on their meds and they've been approved by a psychiatrist, then we can treat them for their SUD. So once they meet the criteria for their pre-screen, we set up an admission. We provide transportation. So we always work within the community to help the residents here first. We will go out to counties in the surrounding areas if there's a need, but we always start in the town that we're located. So clients will come in, they'll meet with a case manager who will do their intake assessment, they'll meet with a doctor, and then they'll meet with their clinician who's going to be working with them throughout this day. 3.5 is typically anywhere from 21 to 30 days of care. In there, they are treated for any withdrawal symptoms. So we do see a lot of opiate use, so that would be Suboxone or Subutex. We will not be providing methadone. If clients do come in on methadone, because we have seen that in the past in Virginia, and they want to get off of it, we'll use other medications. I don't want to bore you with too many details, but we'll use Subutex, which can get them off the methadone, and then, correct. So once they have met with the doctor, they'll be assigned their room. As Mr. Rose said, this is a 24/7 facility. So these clients, this is not a lockdown facility. This is not court-ordered. They are not remanded there. This is a voluntary program. And so, again, 21 to 30 days is the timeline. Their days will consist of breakfast in the morning and morning meds. Then they'll be seen by the nurse to check vitals, as he said, every 30 minutes to make sure that anybody going through detox is being properly medically treated. There will be group therapy conducted by licensed clinicians in the state of Virginia. Those groups are usually about an hour long, then they break because at this level they're still going through a little bit of withdrawal symptoms. They can't sit too long. Lunch is at 12 to 1, afternoon groups, and then in the evening we do activities depending on what they're able to do. Sometimes they're going through such withdrawals that they're just staying in their beds and sleeping quietly. Other times there'll be activities throughout the evening. When I said this is not a lockdown facility, so a lot of questions I get is whether a client wants to leave before their treatment is over. So we are always a bed-to-bed facility. So if a client comes to us and they want to leave because they miss their family or they just can't do it anymore, whatever it is, we'll try and work with them. We call it an AMA block, which is against medical advice. We'll sit them down with the clinician, work through that. If we can't get them to stay, we always work with another facility to refer them to so that clients aren't walking out the front door and walking around aimlessly with their suitcase downtown. So we always look for that, or we will provide them transportation away from the facility and back to wherever they'd like to go. 24/7 that he had mentioned, I just want to talk a little bit about that. The staffing of the facility has an MD and a psych. Sometimes that will be a psych NP, like a nurse practitioner.
Right.
RN staff and LPN staff will be round the clock at this level of care. And then we have BHTs, which are behavioral health technicians. Those are like an orderly, if you will, at an elder care facility. They're the ones making sure clients are going to group, they're eating their lunch, they're not making messes, things like that. So it is 24/7 staffed, and there's always an on-call medical director available if there are any emergencies after hours. So I don't want to go on too long because I'm sure there's questions, but that's pretty much an overview of how the facility will operate, and I'm happy to answer any questions if now's the appropriate time.
Commissioners, do you have any questions of the applicant?
Yes,
I-
go
Go ahead.
Yeah, I do.
Go ahead, Commissioner Jacobs.
I heard you say it'd be up to 85 individuals who would be able to participate in the program, correct?
Yes, ma'am.
And they are not mandatorily required to be inpatient at the facility, is that correct?
No, they're not being court-ordered or mandated to with us. It's a voluntary program. Once they are inside and have completed their intake, they are not allowed to come and go as they please. So they will be there for the remainder of their care. If they left early for whatever reason, we would make sure they're transported to another facility or back home, but not just allowed to come and go as they please.
Will you have on-site security?
So we don't use on-site security. It's a question that does get asked a lot. It doesn't provide what you might think it would. It's actually somewhat of a deterrent sometimes to the clients receiving care. We use the use of security cameras and the key fob locks. So the doors are locked, so nobody outside can come in without being let in by an employee. And they could leave out of an emergency exit, but the way that the facility is structured, they would need to come through the front, and there's staff 24/7 there to prevent them from just walking outside.
But what about security protection for the other residents? I mean, because if they're in a drug treatment program,
Sure.
rehabilitation program, there is the possibility that during their treatment, they could become aggressive. So what type of security will you have to protect the other residents? I'm just very
Sure.
curious how that would work.
I can only speak from my experience. Very rarely do we see that level of aggression from clients that are seeking treatment for drug and alcohol abuse. All of the staff is trained in de-escalation, so if there is something like that, maybe a fight with another client, or they get, agitated, they have protocols in place on how to try to de-escalate, and then if they need to call 911. But very rarely have I ever seen a client get that agitated where there's been a need for security outside.
And none of your facilities have security on site?
No, ma'am.
Thank you.
No, ma'am. If I can, just one more. Think of this as a hospital. When you drive by, you don't see the hundreds of people that they're treating inside because they're in their beds. And that's exactly what this facility will be. They will all be inside, and if someone does leave, they will be escorted by a staff member somewhere else. They will not be wandering the streets.
But when you say escorted by a staff member,
Yes.
what would be the title of that staff member?
That would be a BHT. It's a behavioral health technician. So those are like the orderlies that I had mentioned. And we always have them staffed so that if they need to drive a client, we have vans that we use for transportation, and they would drive the client to their next location. We do not allow clients to just walk out the door.
Okay, thank you.
Sure.
I had tons of questions for you.
Sure.
But you were so well actually able to present your presentation.
Thank you.
That you answered majority of my questions. Being in this field for 21 years, I do this for a living.
Understood.
And so I had many questions you were able to answer. One of my questions is Genuine Care Consulting is the owner of
We are
this-
not the owner. So we get hired on by the owner of the operations for the company, and we help them structure policies and procedures, help them with staffing modules. We do interviews for them to hire directors of operations, nursing staff, because we're familiar with the processes.
So what's the name of the company that will be?
I'm not sure the name of that company. I know the gentleman's name who is going through the use exception, but I don't have the name of the actual company that will be operating.
What is the name of the person who's going?
So his name is Isaac Wettenstein, Wettenstein.
Spell that one more time, a little slow for me.
Sure. No, Isaac, Isaac. Last name is Wettenstein, Wettenstein.
Does he have any other facilities that's in the state of Virginia?
So he does not, which is why he hired us. We've opened 3 in Virginia in the last year.
Okay. Being that they're going to be allowed to leave the facility, how often would you guys be drug testing?
So drug testing is twice weekly.
Okay.
So those are the 12-panel cups that test for most regularly used substances. And then we do make use of Quest or LabCorp to test for other analytes that may not be on the 12-panel.
So this would be almost parallel to similar residential crisis or PHP kind of?
Yeah, so PHP, the hour requirements.
Partial hospitalization for people who don't know.
Yes. So PHP, partial hospitalization, most of the clients are living in either a sober living or a low-intensity place and then going to the facility for their groups and their individual therapy, so a lot of traffic coming in and out, whereas this isn't. So this is where they would reside and get treatment all in the same place.
Thank you, sir.
Sure.
Are there any other commissioners that have any questions at this time?
I have another question.
Yes, Commissioner Jiggets?
The Mayflower House, so it's not in operation now? Is that what you're saying?
I'm not familiar with the actual property. I couldn't speculate.
Okay, because I think
yeah.
it is.
Yeah, my understanding is that it is shutting down, that it has been operational, but it is planned to close.
When is the operation ceasing under the regular residents who were living there?
I'm sorry, I didn't quite the...
When is it shutting down? Because I know there were residents in that facility not pertaining to anything dealing with drug treatment.
Mm-hmm.
So when is that supposed
I'm
to happen?
not sure the exact date. I know that there are still residents in there currently, but I think pending this approval and I think the sale of the property, I think that operation is winding down. I don't understand the business reasons, or I'm not familiar with the business reasons on why that facility is closing, but it's closing regardless of this operation.
Thank you.
Yes, ma'am.
Are there any other commissioners that have any questions for the applicant? Thank you so much. Madam Secretary?
Thank you for your time.
Thank you.
Thank you, Mr. Chairman. Ladies and gentlemen, this is a public hearing on item UP-25-10. I have one registered speaker. As I call your name, please come forward, state your name and your address, and you will have up to 5 minutes to speak. Donna Biggs.
Good afternoon. My name is Donna Biggs, and I live in the Woodbine Farms neighborhood in Churchland. I have no problems with what they're talking about, okay? So I'm going to look at it from a different point of view, from the beginning. It would have been nice coming here and having all the information he talked about available, so I would have more than just this to talk about. So the Link District is being promoted by the Economic Development Authority. So how did they then present this information over here to the Planning Department? And they already talked about behavioral health. And it would have been good to know how behavioral health has integrated their help with this agenda item. The other thing is this. What I'm finding in Portsmouth, the communication line is down. So I don't know what voting precinct this is going to be in, but how did the civic leagues know about this ahead of time so they could know what they think about this land use? So basically, communication. How did the people know? I didn't know about this until I came, and that's why I came in, to learn something. So how is the communication going out to the people? I mean, is that the whole LinkedIn district, and that they're going to have a facility built in it? And so I went to the Economic Development Authority meeting, and they talked about LinkedIn and what was going on and the logo and stuff like that. So it's like they haven't formalized how the LinkedIn would develop and be completed. So with him coming in and talking, it raises concern for me alone, I'm sure. But I just want to share my ideas for communication. Thanks for listening.
Thank you, Ms. Biggs. Ladies and gentlemen, this is a public hearing on item UP-25-10. If there's anyone here who did not get an opportunity to register and would like to address this application, you may come forward, state your name and your address for the record, and you will have up to 5 minutes to speak. Appearing to be none, Mr. Chairman, members of the Planning Commission, this public hearing is now closed.
Is there any more discussion needed? If not, we are in need of a motion and a second.
I motion to approve item UP 2510.
Is there a second?
Second.
Thank you, Commissioner Glover. Madam Secretary, we have a motion and a second.
Thank you, Mr. Chairman. Motioned and second to approve UP-25-10, and you will be voting electronically. This item is approved by a vote of 5-1. Our next item, CA-25-01 Citywide. The City of Portsmouth proposes to amend City Code, Chapter 9.1 Chesapeake Bay Preservation Area Overlay District Ordinance to include provisions to assess the impacts of climate change and sea level rise on proposed land development in the resource protection area during the project review process as required by Virginia State Code 9 VAC 25-830-155. The staff coordinator is Valerie Malzone. And if you could come forward and present your application for the City of Portsmouth.
Good afternoon, Planning Commissioners.
Good
Good
afternoon.
afternoon.
My name's Valerie Malzone. I'm a principal planner with the City of Portsmouth. So local compliance with the Chesapeake Bay Preservation Act is overseen by the Virginia Department of Environmental Quality, or DEQ. DEQ has requested that the city provide a copy of the proposed ordinance amendments for review prior to adoption. Planning Department staff is recommending deferral of this case to the October Planning Commission public hearing to provide additional time to review and incorporate DEQ's comments into the ordinance once received to ensure proper compliance with the state requirements. The proposed amendments were submitted to DEQ on August 20th, and the deadline for ordinance adoption is October 31st, 2025. That concludes my presentation. I'll stand by for any questions.
Commissioner, do we,
Yeah, I have a question.
Commissioner Jakes?
Did you say that, you said something about September to what?
So the proposed amendments were submitted to DEQ for their review on August 20th. The deadline for ordinance adoption is October 31st, 2025. So I didn't mention September this time, but yes.
You didn't mention anything about September?
If I did, it was by mistake.
Oh, okay, all right, so noted. That's it.
Commissioner, any more questions for the applicant? Madam Secretary?
Thank you, Mr. Chairman. I do have one, thank you, Ms. Malzone. I do have one registered speaker, Donna Biggs. You may come forward, state your name and your address for the record, and you will have up to 5 minutes to speak.
Good afternoon again. Donna Biggs, Woodbine Farms neighborhood, Churchland. This just goes to show again that here I am and I'm seeing all that, but I don't see the documentation to show me what is being planned so I could come up here and say something. I mean, there could have been a map to show where this Chesapeake Bay Preservation Area Overlay District ordinance, or the overlay district, would be. You could have a map up there and show people, okay, let me say this. I'm a visual learner, action. And what I'm seeing there today, that the learning style is hearing and do nothing. So, okay, but I'm just going to share with you, I'm a visual. So when they said that, okay, let me see it. So I just want to share with you that learning styles are very important in our education system. I ain't the only one that learns by visual. There are kids in school that need to be honored to have their learning style appreciated. And if a kid came up here learning style, and if you said something, it wouldn't be appreciated. But anyway, thanks for listening, and let's address learning styles too when we give presentations. Thank you.
Thank you, Ms. Biggs. Ladies and gentlemen, this is a public hearing on item CA-25-01. If there's anyone here who did not get an opportunity to register and would like to address this application, you may come forward, state your name and your address for the record, and you will have up to 5 minutes to speak. Appearing to be none, Mr. Chairman, members of the Planning Commission.
Is there any more discussion that's needed concerning this item?
Pardon me, Mr. Chairman, I do need to ask our legal, do I close this public hearing since it's going to be deferred, or do I keep it open?
I'll keep it open.
Keep it open, okay. Okay, seeing no other speakers, Mr. Chairman, we will keep our public hearing open until our October the 7th, 2025 meeting. We are in need of a motion.
Commissioner, we need a motion and a second.
Motion to defer.
Second.
We have a motion and a second to defer to our October the 7th, 2025 public hearing, and you will be voting electronically. This item is deferred by a vote of 6-0. Our next item, CA-25-02 citywide. The City of Portsmouth proposes to amend Chapter 33.1 of the City Code Subdivision Ordinance to update specific provisions to ensure consistency and compliance with recent amendments to the Virginia Code as enacted through HB 2660 and SB 974, which becomes effective on July the 1st, 2025. The staff coordinator is Patrice Branch. Can you come forward, please, and present your case at this time?
Good afternoon, Planning Commissioners.
Good afternoon.
My name is Patrice Branch, and I am a planner with the City of Portsmouth. So last month, staff provided you all an overview of recent legislative changes that were enacted during the 2025 Virginia General Assembly sessions. These changes impact the local land development processes, and as a result requires updates to the local subdivision ordinance to ensure compliance with state code. Following that presentation, the Commission adopted a resolution initiating staff to prepare amendments. You want me to start over? Or I got the Commissioner adopted. Okay. The Commission adopted a resolution initiating staff to prepare amendments to the city subdivision ordinance for your consideration and with the intention of future adoption by City Council. Today, I'm just going to go over the proposed amendments to the subdivision ordinance. Okay, so to begin, listed here is a brief summary of the key 2025 Virginia Code amendments. Senate Bill 974 essentially removes the approval authority from the Planning Commission and governing body and assigns the authority to the designated agent. House Bill 2660 shortens the review timeframes for approvals for plats and plans. Additionally, in addition to aligning with these legislative updates, many of the proposed amendments include routine adjustments that will improve the clarity, consistency, and usability of the ordinance. These proposed changes falls into 3 categories. So first, staff is proposing amendments to the authority, administrative/enforcement, subdivision exceptions, and major subdivision procedures chapters of the ordinance. These sections are being revised to reflect the changes that came about as a result of Senate Bill 974, which again shifts the approval authority from the Planning Commission/governing body and assigns it to the designated agent. Second, staff is proposing amendments to the procedures for preliminary plan review for both minor and major subdivisions. These changes are required to comply with House Bill 2660, which shortens the review timeframes and outlines new procedures for plan resubmittals. And then lastly, the following sections that are listed here are the routine adjustments that staff are proposing amendments to. These include essentially removing outdated references to the Virginia State Code sections, adding additional submittal requirements to reflect current review practices, and addressing other areas in which the subdivision ordinance was not in compliance with state code. So overall, staff is recommending approval of the proposed amendments to update specific provisions of the subdivision ordinance. These updates will improve the clarity and consistency in the administrative review process and ensure compliance with the Code of Virginia. This concludes my presentation. I'll stand by for any questions.
Commissioners, do you have any questions for the applicant? Madam Secretary?
Thank you, Mr. Chairman. Ladies and gentlemen, this is a public hearing on item CA-25-03. I do have one registered speaker, Ms. Donna Biggs. You will have up to 5 minutes to speak.
Good afternoon again. Donna Biggs, Woodbine Farms neighborhood in Churchland. So I would have liked to seen an example of what you're talking about, the subdivision ordinance. So to improve clarity, consistency, ease of understanding what they're trying to say, have an example of the ordinance that you're trying to enforce. The other thing is they had assigned a designated agent, and I would have liked to know in what area would that assigned agent be in? Planning, zoning, EDA, PPIC, whatever. So I'd like, when I'm learning something, I'd like to have a whole complete idea. So when I come up here, I know what I'm doing to say exactly what needs to be done. So exactly what needs to be done is to have an example of what you're talking about. Thank you. Have a good day.
Thank you, Ms. Biggs. Ladies and gentlemen, this is a public hearing on item CA-25-02. I have no other registered speakers. If there is someone here who did not get an opportunity to register and would like to address this application, you may come forward, state your name and your address for the record, and you will have up to 5 minutes to speak. Appearing to be none, Mr. Chairman, members of the Planning Commission, this public hearing is now closed.
Before I move on, I want to make sure that we understand that any staff reports are put on the website a week before the meeting. So any other literature that needs to be reviewed, you can go on the website and you'll be able to see it a week before the meeting. Is there any more discussion about this item with commissioners? If not, we are in need of a motion and a second.
Motion to approve.
Thank you, Commissioner Glover. There be a second?
Second.
Thank you, Commissioner Jacobs. Madam Secretary, we have a motion and a second.
Thank you, Mr. Chairman. Motioned and second to approve CA-25-02, and you will be voting electronically. This item is approved by a vote of 6-0.
Madam Secretary, I believe that concludes our agenda for today. Is that correct?
That is correct, Mr. Chairman.
Commissioners, will there be any more further business? Dr. Russell, is there any more further business for us today? Hearing there is none, this meeting is now adjourned.